Good evening, folks. Thanks for joining us for this segment of Wave Extra. Of course, starting the week and, starting on what the note is, of course, with closing arguments. Now, fair enough, up to this point, what we're going to discuss are what defense counsel has brought up when it pertains to the trials of Brooks Houck and Joseph Lawson, again, relating to Crystal Rogers. For that analysis, of course, always happy to be joined by our analyst, Leland Holbert. So, Leland, thank you for coming in. Of course, we were having our conversations over computer last week. Here we are kind of getting ready to the, we'll call this the crescendo because we're getting so close to the jury's decision. I wanted to ask you, and perhaps, this opens the conversation to just sort of the strategy, which, I love asking you about, sort of the time that, at least to my knowledge, both counsels on the defense collectively have taken up to make their closing argument, whether you argue, is it, I believe the attorney for Mr. Lawson's Robert Boyd, and then the attorney for Mr. Houck, Brian Butler. But just kind of touch on, the length that they might use to talk to the jury in a closing argument.
So, length of a closing argument usually depends on how much they have to say and then the length of the trial. So if you have a 6-month trial, you're going to have a very long closing, typically. You have to tie up the things you want the jury to hear, but closing is about the building blocks that have been laid during trial. So if something was big during trial that's defense friendly, they're going to point that out. They're going to hammer the holes, hammer the holes, hammer the holes. And I assume that's why it's taking so long for them to close today. They're probably taking the route that, well, there's so many holes, that's why my closing has to be so long. So they keep hammering the inconsistencies. I think their theme was kind of like, this is a witch hunt, and that's a fairly popular theme. And, I think it goes along with what they've tried to prove this entire time or disprove, and then goes along with the witnesses and experts they hired.
I was going to go through some notes and some points here, but you'd argue, of course, it benefits defense counsel to at least convince the jury of this, for example, in the term of the witch hunt. And I might have to go back and find like a specific article where I guess they bring back the governor being on record about just hoping for resolution. Maybe, he might argue it's an innocuous statement, but if you are defense, what you want is justice, not at the expense of someone. You'd want to have the proof beyond a reasonable doubt there, right?
Yeah, you always see sometimes skilled defense attorneys sneak in things that maybe they shouldn't, because closing argument is supposed to be centered on the facts that were brought out in trial. And if the governor said, the notes say that they're quoting the governor as ordering this case to be resolved. If that happened, fine. I doubt that came out during the trial, but it's possible. We didn't have a transcript of everything that was said at trial. No. So maybe that was said at trial. But that's obviously goes along with the defense theme that this was brought about by pressure and not by evidence. And that's going to be their entire theme, is that, they found someone that they thought they could pin this on, or they just focused on a single target and did whatever they could do to prove that target was guilty. But at the end, by the end of the day, they are arguing that the evidence was simply not there, or not enough, or inconsistent. And, they're just throwing all these words around, all these terms around. And I think they have a rational basis to do so. But clearly it's to establish reasonable doubt. And the prosecution, I'm sure, is going to fire back with, well, there's a missing mother, and there's Brooks Houck was very close to her, and, he lied about his story, according to the prosecution. So, it's a lot of back and forth, and I saw the defense for Joseph Lawson gave some concessions about, well, my clients may be stupid, but there's no way Brooks Houck, who's an intelligent businessman, would hire such idiots and alcoholics to help him.
Something around the word of like fools or idiots around, right?
And that's interesting, because that's asserting a defense, and also kind of a gentle nab at Brooks Houck, saying this guy's very intelligent. He's a businessman. He probably did this, not me, without saying that. So Joseph Lawson's attorney's doing what he's supposed to do. Brooks Houck attorney's doing what he's supposed to do. I'm sure the actual presentation to the jury is more fiery than just notes and what we're seeing on a piece of paper. So I'm sure they're being very animated about their client's innocence and about how the law enforcement has manufactured evidence rather than found solid evidence.
And would the jury, perhaps, again, I see the strategy and the defense sort of hammering the point home, if they were kind of highlighting what they argue are the gaps in the testimony and the evidence when it comes to witnesses and in the impression that they might have left, for example, with Mr. Boyd, if that's the quote from the note saying, two of the more untrustworthy witnesses he's ever heard from in Charlie Girdley and Heather Snell, and you presume he's had quite a career, obviously, but
Right.
for effect to tell the jury, does it, I know this question is probably more anecdotal, and how much weight do you find the juries will give an untrustworthy or trustworthy witness versus, not, the meat and potatoes of the facts that you present?
Well, that's their job. Their job is to measure and weigh credibility. So I wouldn't say a witness automatically comes in as trustworthy or untrustworthy. The jury can decide that.
Okay.
Based on their mannerisms, based on their responsiveness, based on their intelligence, and really how they handle cross-examination is a big part. Because if you're telling the truth and you're competent, you can typically answer questions pretty easily. And if you're lying, or if you're manufacturing a story, if you're paid to give an opinion, sometimes you falter under cross-examination. So I tend to think juries listen and absorb the cross as much as they do the direct examination, if not more.
Okay. I'm thinking ahead just to sort of, when we'll process whenever the prosecutors or what we think they might approach. But now focusing on Brian Butler and the notes he left. I was interested in his description of something he thinks defense attorneys usually approach versus prosecutors. And the way the notes we have for his quote is saying, is it possible? When he says that, what do you think he's trying to get at, and for the jury to understand as far as like a role reversal maybe is what he's trying to get at?
Yeah, I think he was trying to point out that, he, much like me and a lot of other defense attorneys, are former prosecutors. So he can comment intelligently about what a prosecutor should do or normally does. And usually, I think he's trying to say that the defense is typically tasked with throwing out red herrings and throwing things against the wall and saying, isn't it possible, isn't it possible, isn't it possible, because the prosecution has a strong case. He's trying to flip the script and say, well, that's what the prosecution's doing, which shows you they have a weak case. I don't know if that's necessarily true, but that's his tactic, and that's, it's an effective way to argue the other side. Mm-hmm. And that's the benefit of being a former prosecutor and now a defense attorney, is that what a typical prosecution case has. So he's almost giving some, and I don't know if he's divulged he's a former prosecutor, but probably. And so he's giving some insight as to even more reasons why this case is not what it should be.
Okay. I know this is a weird or just a quick tangent on something that Mr. Boyd had said, where he described the cell phone data and the testimony that was provided as the North Star for the prosecution. We can look at all the different pieces that they have brought forth. Is it fair to try and comment on what we think the prosecutor is hanging its hat on as far as evidentiary, whatever they're able to provide?
Well, both defense attorneys have mentioned how that is the linchpin of the prosecution case. I don't think the prosecutor would agree with that. I think the prosecutor's smart enough to say the linchpin is a missing mother, is a body that was hidden on purpose, something like that.
Sure.
Now, their best evidence may be the cell phone data, because it is physical evidence. It can be attacked, it can be analyzed, it's data driven. So that's probably what the prosecution would say, and because it's not perfect evidence, the defense is going to try to say, well, this is their entire case, and it's a faulty science, or it's not perfect. And, that's just, it's all argument at this point. Mm-hmm. So they're trying to sew things up for the jury and use the breadcrumbs that are most favorable to them to lead them to the result or the end of the story they want. Mm-hmm. And there's going to be two different stories from the prosecution defense. That's one thing I would guarantee. And the prosecution has the benefit of going second. So knowing these prosecutors, I'm sure they will comment on some of the things brought up by the defense because they want to undercut them and say, look, yes, they said this. That's why this is completely not true. And so, you always want to go last. It's just the nature of any conversation. Some people like to have the last word. Well, unless it's a death penalty case, the prosecutors always have the last word.
Okay.
And so that's I think, a small advantage for the prosecution.
Do you think, for example, and this might just help tie up for another comment Mr. Butler had made, and maybe this speaks to, what their commentary is going to be on police's actions through the investigation case, but he was talking about this, quote, myopically tunnel visioned on one suspect and not trying to, spend the energy on an alternate. I don't know if, you have to imagine if the prosecution would likely push back on that assertion by the defense, right?
Yeah, I mean, if I'm the prosecutor, I'd say, Brooks Houck was a target because of all these things that point to Brooks Houck. But the defense spent a lot of time saying, well, you analyze the 100 different pieces of evidence. That's not really consistent with tunnel vision. Mm-hmm. But, I think that that's a popular argument for the defense. And it happens occasionally or often. Police, they typically don't get years to investigate a case. Here they did, but they had to make some decisions early. And the evidence, typically you're going to start with a spouse, a husband, mm-hmm. something like that, and then exclude them and go elsewhere. Well, they couldn't exclude Brooks Houck, and they found some inconsistencies. So did they stay there? Yes. But to say they only focused on Houck, that's a little bit misleading because they've obviously charged 2 other people. There's unindicted co-conspirators. There's hundreds of things examined. I would focus more, I think, as a juror and observer on maybe the lack of physical evidence or the DNA issues or things like that. But it's more of a human element to say that Houck got railroaded or, whatever they're trying to argue. I mean, it's a popular defense.
For sure. And of course, wishing we had the notes to discuss perhaps what either Mr. Young or his co-counsel were going to discuss. But is it generally par for the course that however much time the defense will take to establish their closing argument, that the prosecution would want to take the same amount of time and patience to go, rebuttal here, rebuttal there, and then sort of drive the point home?
Not necessarily.
Not necessarily?
I think you've also got to meet your personality. All right, some people like to talk, some people like to grandstand, some people like to make grandiose arguments, and other people are more to the point. I would say Brian Butler is a little more theatrical in his presentation, and that appeals to juries. Shane Young is a little more direct. So I would expect, all things being equal, Brian's would probably be a little longer than Shane's, but who knows? Mm-hmm. I mean, I think the jury's going to be tired. They just had a holiday weekend. They're probably feeling the effects of that, and then they've got to listen to people talk. And it's like being in class. People can listen to a teacher for a certain amount of time, but listening for hours can be difficult. And Brian's could possibly trying to wear them down, mm-hmm. and then Shane's left with a bunch of tired jurors. Does that change the whole case? Probably not, but that's a potential strategy.
Mm-hmm. What's it like just to put us in your shoes about the night after you finish closing arguments, and in a case like this, if you've had the time where the judge says, okay, here's one more night, we're going home to sleep, and then you're coming back, Mr. and Mrs. Juror, to start deliberating. What's, put us in the mindset of kind of the mood or the mentality for them as we look ahead toward, tomorrow morning for Tuesday?
Well, first I'll say I've never seen that happen.
Really?
I've never seen closing arguments at the end of the day and deliberations to start the next day, because the way I think a lot of judges look at it is the closing argument, after that second it's over, it's now the jury's case. This bubble has formed, and they need to stay in that bubble and start talking. And you're giving them another, 12, 15-hour gap, and I don't think that's recommended. But in this case, I can see why they did it, because there was already a 3-day break. The closings were going to be lengthy. The jurors are probably exhausted, or will be after the Commonwealth's closing. So I can see why the judge did it. I'm not sure I've ever seen that done. I've seen a lot of cases where we'll say closings are tomorrow morning.
Okay.
And then at 8 a.m. they start the closings, and then the jury starts deliberating at 11 or whatever. But this case is a little bit different. It went so fast to begin with, and now it's slowing down a lot at the very end, and that's just the way it's going.
Okay. Any other thoughts? As I'm trying to go over any other more notes, but before we wrap up for today, Leland, anything else on your mind, at least for the viewing audience at home, if they've been following this as closely as we think many of them have, and just sort of what your take on everything is?
So every attorney can learn a lot from talking to the jury afterwards. And this would be a fascinating case to hear what the jury thought. And I'm sure a couple of them will talk. And, I'll be very interested to see what they say, because all the specials and all the oxygen things and the
Documentary
news specials,
here.
everything you've seen, and now the two trials themselves, you don't really get a taste of everything because we can't watch it. And so the jury has watched every second of it, and I'm curious what their impressions will be. And as far as predicting which way they're going to go, I think it's difficult. I don't think this one is clear, and that doesn't mean that it's pro-defense or pro-prosecution, but it's certainly not a slam dunk either way.
Okay. All right, well, that will do it for this analysis segment on Wave Extra. Always appreciate our insight and expertise from our Wave legal analyst, Leland Hulbert. And as we break down, of course, what's going to happen Tuesday morning and beyond, I can only assume we're going to, check in with Leland as we find out whatever information unfolds. And worth noting, maybe I didn't tell Leland this, I'll be part of the crew there tomorrow morning helping Alina, so I'll make sure to check in with you down from Bowling Green and see what we all see play out of the courthouse. So again, appreciate Leland's time. We're going to take a quick break. Be right back here on Wave Extra. All right, everyone, good evening. Thanks for joining us for this edition of Wave Extra on Monday, July 7th, and an important Monday because it's the day before we presume the jurors in this trial involving Brooks Houck and Joseph Lawson heading into tomorrow morning are going to start deliberating everything that both prosecutors and defense attorneys have put before them to weigh the evidence, any reasonable doubt as far as these two men's alleged roles or contributions in what happened to Crystal Rogers all those years ago. And up until this point, you've been able to hear our notes, our analysis, our breakdown of everything that's been, discussed and said inside the courtroom through sketches and the notes. And to that end, we have to thank our reporting crew down there for sharing that with us. And of course, today, likely a day where both sides of attorneys tried to make their last pitch to the jury. And so differing perspectives on that. And to break all of that down, we're going to bring in our Wave News reporter, Alina Noakes, outside of the Warren County Courthouse. And so, Alina, I wanted to start with the latest comments you just heard, because they came from the prosecution, who they do have the last word, and just break down. I believe it was Shane Young kind of taking the torch there. Really, what the crux of what he was trying to say, and different points in his story that stood out to you.
Yeah. So. Honestly, the case here, the pitch to this jury could not be more different from the prosecution to the defense. I mean, obviously so. Look, we're dealing with a circumstantial case with the prosecution. The prosecution has admitted that, but the defense has really taken that as an opportunity to point out all of the areas that they don't have physical evidence, all the areas where the defense says this circumstantial evidence does not ultimately add up to a conclusion that this jury could reach a guilty verdict. But let's really talk about what the case for the prosecution is. What kind of things are they highlighting here? They've said since the beginning they want this jury to use their God-given common sense and say that it's crucial here to help fill in those gaps. And there's a reason why they're pointing out this as a method for this jury to use. This is as a way for them to reach a verdict in this case. They really are pushing for that in the analysis of Brooks Houck's timeline, specifically what he didn't tell them, what he did tell them that we've learned through witness testimony it has not been true, such as who he dealt with the day of July 3rd and where he was at. We know now that based on his cell phone data, he was actually at the Houck family farm for a majority of the day, but in a multi-page statement that he wrote to police, he only notes that in one line. There's about an 8-page statement there, and he only notes in one line that he was at the farm that day. Everything else, he says he was running around to properties, dealing with different people, from financiers to contractors to development agencies that he was working with on different properties. So they really asked this jury to point out the areas that seem to be inconsistent to them and to focus on those, as well as just things that appear to not be right. So the defense has said before in their opening statements that if you look at anything with a sinister way, you're going to come to a sinister conclusion. But the prosecution says sometimes things aren't just looked to be sinister, they may actually be sinister. It doesn't always, it's not always based on appearances. Sometimes those are actualities. So they look to that for things like the grand jury statements, the family phone calls that Brooks Houck dodged in the hours after Rogers disappeared, his seeming lack of urgency to look for his girlfriend, who usually would sleep in late on Saturday mornings, but on that Saturday morning of July 4th was not to be found in their bed or even in their house, her car missing, all these little details, and only 2 phone calls to her that day of July 3rd, or July 4th rather, in the hours after she had been last seen alive. And all these things, prosecutors say, they just aren't right. They don't add up. And in their view, they lead this jury to a conclusion that sometimes things that appear to be sinister may actually be sinister. Ultimately, they say that Crystal Rogers, her disappearance, the fact that she never returned home that night, doesn't appear to be argued in this case, and that if the jury looks at that, they should see that the last person she was believed to be alive with, that being Brooks Houck, should be found guilty of her murder. Now, I do want to emphasize that in jury instructions that were submitted, the jury is going to be able to consider some different elements to murder. So right now we know that Brooks Houck is charged with complicity to murder, but that's a statute or that's rather a level underneath the statute of murder. So they can actually find him guilty of murder, meaning he acted intentionally to kill Crystal Rogers, whereas complicity would be that he encouraged it or he helped in killing her. And then they also can find him of an even lesser offense than complicity, which would be principal to or an accomplice of. Essentially, the jury would find they can't determine whether he was the principal act in the act of killing, or if he helped to aid in the killing of Crystal Rogers. Also on this case, case, Joseph Lawson is also being given the option of facilitation to murder as opposed to conspiracy to murder. That's a lesser offense. His dad, Steve Lawson, also had that option during his trial. Of course, the jury in that trial found him guilty of conspiracy and not facilitation. So these are kind of the elements that we're looking at of that final pitch to jurors from prosecutors and what they're left to think about as they also consider what charge might be best suited when they're making a verdict in this case.
And Alina, thank you for mentioning sort of the nuances and the degrees with which the jury can weigh, you know, the sub-charges, if you will. I know there's a better terminology for it, but just understanding there's differences of degrees involved to it based on what they come to a decision on. And to that point, I'm curious, perhaps as you were sitting down and listening to the defense's, you know, opening lines, their opening stanza, and obviously, you know, each one with Mr. Boyd for Joseph Lawson and Mr. Butler for Mr. Houck, sort of, you know, how they're trying to, I guess thread the needle, so to speak, in the cases and how it pertains to their client's alleged innocence. What did you see sort of their approach was with the jury this afternoon?
Well, really, it was to point out that for the defense in this case, that there was this conspiracy. They basically were saying that the prosecution didn't prove this, and that if anything, there was a conspiracy with investigators to reach one conclusion and one conclusion alone, meaning that Brooks Houck was guilty of this crime. They said there was an overriding directive, that's the word Brian Butler used, to, quote, get Brooks Houck for Rogers' murder. Both he and Joseph Lawson's attorney, Robert Boyd, characterized this case as a witch hunt. And basically, Boyd put it that witch hunts were deemed to not be right years ago, and that seems to be the situation that they are encountering now. Butler spent time picking apart each witness and each bit of evidence, and then lack thereof when it comes to physical evidence. He highlighted every situation there. Specifically, there was never a body found. There's no DNA found. Even the lack of bringing up people like the FBI or different investigators who worked on this case to testify about the different searches they did. We didn't really hear that during the prosecution's case, but the defense brought up their own witness on the very last day to testify about those searches and what they didn't find, which is any sign of Crystal Rogers, any sign of DNA evidence. Of course, we do have things like Anna Whiteside's car and the hair found back there, as well as a canine who detected the scent of human remains. But the defense wants to also put questions on that. Namely, they offer today an alternative person whose hair that could have been, which is a relative of Anna Whiteside's, who had blonde hair as well. And then they also, of course, casting doubt still on the canine that was used to detect that human remains scent, saying that there's no record of training, and that, of course, the cross-training of that dog, which we know to be the case here, that they detect both living and human remains, could lead to an inaccurate interpretation, especially when no forensic evidence was found in the back of that car. That the forensics team found, at least. So you have all of these little elements working together the defense really wants to highlight to the jury, and you know, it's going to be up to a juror to determine whether or not how much weight they put on the circumstantial evidence and on what the prosecutors are telling them when it comes to filling in the gaps of their common sense. How much does the common sense really work in this situation? But the defense asked them to do the same thing. Use your God-given common sense, and they're of course hoping that they're going to fill in the gaps with more definitive answers than maybe what prosecutors are asking them with those conclusions, what they're asking them to come to. So really two conflicting arguments here. And you know, the prosecution has never said that their case is perfect, but they argue that it is enough and it's convincing enough to get this jury to a conclusion that Joseph Lawson and Brooks Houck are both guilty of the murder of Crystal Rogers. So these are kind of this intersection of things that we're dealing with when it comes to these two arguments, and it's going to really be up to these jurors to decide which one they find to be more convincing. And I heard you talking to Leland right before our I think that was the 5 o'clock show in my ear, just talking about how it doesn't seem like either situation here, there's like a slam dunk case. There's plenty of reasonable doubt potentially on both sides. At least that's what both the prosecution and defense has pointed out in this case. So it's going to really be interesting to see just what they take away. And obviously the jurors are going to have an opportunity during deliberation to also be asking some questions like they did during trial. So we might have a better idea of a direction they are going if we do get any questions during the deliberation phase that's set to start tomorrow.
Which will be fascinating as we go through that process, Alina. And I did want to ask you before you go, put us in the room with kind of, I guess, the sense of urgency or mentality maybe the jury was feeling as, Mr. Young wrapped up his closing, and obviously that would, conclude business for the night. But maybe you heard Leland and I talking about how it's unorthodox that they would have these other 12 more hours before they start taking care of business. What was your sense of how people were feeling inside the courtroom?
Yeah, well, I mean, it is unorthodox to have a gap before you take up a verdict. Of course, it's usually after the closing arguments, the case is passed on to this jury for a verdict. But in this situation, I think it was just a really long day of closing arguments that the court anticipated was going to be the case. I mean, we heard from the defense from around, I would say 9:30 this morning with Joseph Lawson's attorney first presenting his closing arguments to then a nearly 3-hour-long bit of defense from Brian Butler for Brooks Houck, and then we obviously heard from the prosecution also giving a lengthy closing statement and really just walking this jury through their cases, trying to make sure they pinpoint every place they want the jury to focus on and paint an overall picture of what their case is. So it did lead to a lengthier one. I mean, you got to think you're summarizing 2 weeks of witnesses and testimony into one day, and each side gets a chance to do that. So it did lead to a lengthier day for these jurors, but I don't think they were not inattentive towards the end of the day. I mean, this is the longest day by far we've had. It went on till about 6 o'clock our time, I believe, or I might be thinking of that wrong. No, it's 5:51. Sorry, the time change is messing me up. Till about 5:15 or so on our time here in Central Time. So it's the longest day they've had so far. But even towards the end, with Shane Young giving his closing arguments, they had their headphones on. They were listening to all those statements. They were taking notes, and they did that really throughout the defense as well, despite it being kind of a lengthier process. As for the energy in the room, I think, depending upon what side of this case you're on, whether you're with the defendants or the victims, you are obviously, wishing some to get over with sooner than others. But at the end of the day, they're just, really, I think, anxious at this point, regardless of which party you're on, to get to some sort of conclusion. So the energy was definitely a little different today. I think everybody obviously knowing that the end of this case is near.
Well, thank you for that breakdown. Again, our reporter, Alina Noakes, getting all of that insight, and of course, a pretty consequential day inside the courtroom to break down those closing arguments that the jury, heading into tomorrow morning, they're going to be discussing. So we're going to, of course, check in with Alina tomorrow and see, if or how long the process for deliberation is going to play out. Of course, you can always check in on the live blog, all the updates on our, TV broadcasts, on wave3.com, on the Wave News app. Alina will certainly be working to get you those updates as they come in. So again, we'll say goodnight to Alina for tonight. Alina, thank you.
Thanks, Jose.